So good morning, everybody. My name is Faye Stenning, and I'm a marketing manager here at InfoTrack. I'd like to welcome you to today's webinar, where we're going to hear about the new conveyancing quality scheme, practice management standards, and in particular, the important changes that conveyancers need to be aware of. So taking you through today's webinar, I'm delighted to be joined by Ian Quayle, who's Chief Executive of IQ Legal Training. Ian is going to be joined by InfoTrack's Northern Sales Manager, Lisa Edwards. So just before we begin the webinar, I'd like to draw your attention, please, to the Q&A tab. That's located at the bottom of your screen. We will be running a Q&A at the end of this session, so please type any questions that you might have for either Ian or Lisa, along with your name into the Q&A box. That way, if we do run out of time or if your question requires further clarification, we can extract your information and follow up with you directly after the webinar. So without further ado, I am now going to hand you over to Ian. Thank you, Ian.
Thanks so much, Faye. Good morning, everyone. And thank you for joining me and taking time out of your busy schedules to assist. It's crazy at the moment, isn't it? Every month I look at it and think, gosh, next week's got to be quieter, next month's got to be quieter, but it isn't. Those of you that haven't heard me present before, thank you, Faye. Yeah, my name's Ian Quayle. I've done this sort of training for about 18, 19 years. I've done over 1,700 training events and webinars, which is pretty scary, isn't it? And most of the time I'll go up and down the countryside boring people to death, but courtesy of COVID, we're now doing webinars and events such as this. As Faye mentioned, we're going to have a Q&A session, which is great. If anyone has any questions or queries that we don't have time to deal with, or you have any questions arising from anything that I've said, then feel free to drop me a note. I'm more than happy to share questions with Faye and to provide answers to any questions that anyone has as we progress during the course of the morning or thereafter. That's not to say I'm your new best friend, sort of sitting waiting for questions at my desk. Unfortunately, I'm too busy for that. But if there are questions that arise, we'll try and deal with them during the session. If we can't, then we'll deal with them thereafter. I'm delighted to be joined by Lisa Edwards, as Faye mentions, is InfoTrack Sales Director for North of England, and Lisa's going to join me as part of the presentation to talk about some of the products that InfoTrack have got that will help you with regard to good practice. And again, a massive thanks to InfoTrack and everyone that's organised today's event. Without people supporting the profession organising CPD training such as this, then I would have a very quiet life. And in addition to that, of course, InfoTrack have some brilliant products that are useful for practitioners. So it's always worth having a look at their website to see what they've got, what's new and what's in development. So enough of that, let's get on with CQS, what's happening, where we're going and what's important. I always show people this slide because there is a wealth of information that we can utilise to assist us with regard to good conveyancing practice. And some of the things I'm going to be talking about today, we can extract additional information, further detail from some of the sites that I'm referring you to. So the PLA website is a litigation website, obviously, but contains a wealth of information that's useful for practitioners. So people often ask me questions about seller identity fraud. There's a paper written by a barrister called Nick Taggart on the PLA website that's free to access that tells you about identity fraud. It also contains information about recent cases, good practice, etc. And it's sitting there and it's free to access for any transactional property lawyer. So if I was a residential conveyancer with an issue or a problem that required some sort of legal research, I'd probably go on the PLA website as my starting point. Again, as far as boundary issues are concerned, there's a site called Property Protocols. There's a boundary dispute protocol on that site. You can have a look at it. It tells you everything you need to do about setting realistic client expectation in connection with boundary identification. Boundary identification causes problems for residential conveyancers and commercial properties alike. One of the things I will be touching on this morning is the need to make sure that we're aware of what CQS is doing with regard to advice concerning residential leasehold transactions. It's important to know what the government attitude is, the fact that residential leasehold houses are certainly no longer in vogue with regard to Parliament or developers. It's also important to understand that clients need to be aware of the bigger picture with regard to leasehold transactions. And to that end, the Leasehold Advisory Service website, the Leasehold Knowledge Partnership website, and the Association of Residential Managing Agents website all has information that can support what we're saying to clients about leasehold transactions, to provide them with the bigger picture, to provide them with where they can seek advice and guidance about problems with landlords, disputes with service charge, disputes concerning administration fees, etc., etc. So I'll be touching on some of those when we look at some of the things that we'll be talking about today. The RICS website has a consumer guide to surveys and valuations. If you haven't seen it, have a look at it. Certainly worth incorporating into the advice and guidance that you're giving clients about surveys and valuations. It's a sort of a useful consumer guide written for the client to assist the client in their choice of survey and valuation. And then finally, I mentioned a site called Property Law UK, which is a subscription service, which I own, to be honest with you, and which about 20 different barristers, solicitors and trainers contribute each month, giving advice relating to the law concerning conveyancing. Again, as far as that's concerned, that is subscription service. All the rest are free. And to be honest with you, you can get most of what you need from all the other sites. So you don't really need to subscribe at all. CQS, what it is and what it does. Well, the important thing to understand, in my view, and what I want to get over today, is that CQS is a very useful tool with regard to residential conveyances. It's not the sort of curse, it's not a sort of hurdle or a hoop that we need to jump through or overcome, and then is sort of, we create a manual and we put on our desk or put it on our system and we leave it. One of the things that's happened as a consequence of changes relating to CQS, and in particular the guidance, is this sort of reinforcement that what we should be doing is creating procedures and practices that are CQS compliant, and in addition to that, making sure that we're using the information and the systems and processes that we've created. So the important point, the missing link, as it were, I think that CQS guidance is sort of highlighting, particularly with regard to the changes as of the 1st of May, is the idea, is the reminder that this isn't a sort of an exercise that we complete, that we get our accreditation, we worry about reviews and assessments, but that really all we've got is a badge, and that we don't really have to utilize the practices and procedures in our day-to-day work. The big thing is that the idea is that CQS is utilized as a system for good practice, for marketing, for avoiding claims and complaints. So today I want to take you through some of the changes to CQS guidance, to have a look at the changes in emphasis, and to hopefully deal with any questions or queries that you've got. As far as my approach is concerned, I'm practical. I deal with lots and lots of negligence claims and complaints about conveyancers, against conveyancers. I come at residential conveyancing from a very defensive perspective. And I look at CQS as a very useful tool in connection with that defensive process. So my approach, as I say, is very defensive, very much in favor of you and your firm, but at the same time attempting to show you how CQS can be utilized for the benefit of your firm and ultimately for the benefit of clients as well. The conveyancing quality scheme then was designed to improve and maintain quality. Has it done that? Well, to an extent it has. It has set standards. It's created a series of hoops that firms and conveyancers must go through. It's assessed and provides a means of ensuring that we have benchmarks that we can test and challenge our firm against. One or two important things, however, to be aware of: the CQS scheme, the Law Society Residential Conveyancing Handbook are benchmarks against which we are assessed and tested with regard to whether or not we've been negligent, but they are not the sort of ultimate test that needs to be satisfied. The point I'm making rather poorly is that you can comply with CQS, you can comply with the Residential Conveyancing Handbook produced by the Law Society and still theoretically be negligent. The test is, what is the standard of a reasonably competent conveyancer? Zara asks if notes will be available. Zara, hi Zara, yes they will. I'll make sure that Lisa and Faye get a copy of the notes, and I'm happy to share those with you, Zara, so thanks for that. Yeah, if you have questions, you can put them in the Q&A box. I will try and deal with anything that sort of arises, but hope to try and deal with the majority of questions at the end of the session. To attract and retain business, well, certainly from a lender's perspective, they're very interested in firms that are CQS accredited, not interested at all in those that aren't. And therefore, I think we are going to attract and retain business as a consequence of that link. To what extent clients are aware of CQS, to what extent clients are sort of willing to instruct firms that are CQS accredited and not instruct those that aren't, is a sort of moot point. I haven't done any research in that regard and therefore can't really assist. But certainly I think the CQS scheme does assist with regard to preventing claims and complaints. The vast majority of my time is looking at where things have gone wrong in a residential conveyancing process. What could a conveyancer have done better? What could have avoided a claim or a complaint? And I think the important thing here to be aware of is that doing the simple things well is the most important thing. And when we talk about doing the simple things well, what I always advocate is making sure that we're communicating effectively, that we're setting up systems and processes that we put into practice, that we ensure that all members of staff are following the systems and processes that we've got. So hopefully that's sort of, something you're aware of, something you're familiar with, and certainly the changes to CQS aren't doing anything radically different, in my view, to those sort of aims and themes that I've mentioned on slide. Just going to have a look. There are some more issues with regard to sound. Hopefully that's fine. If it is a problem, what I can do is turn my camera off, but hopefully at the moment we're okay. So structural changes with regard to CQS as of the 1st of May. One, we've got more reference to structure and strategy relating to CQS, relating to practices and procedures that our firms are adopting. Secondly, emphasis on people management. And there's a very interesting point to extract from this. I look at what causes negligence claims almost on a weekly basis. I sort of trawl through what professional indemnity insurers are saying. I have a look at case law. And I see from firms that sort of contact me with regard to problems and issues, sort of day-to-day transactional problems that have the potential to lead to claims. And one of the things that's happened over recent years is as follows. Historically, negligence claims arose from procedural errors, sort of not registering applications within priority, not following up on documentation that had been asked for, not advising clients about adverse entries relating to searches, not doing searches, not getting searches back in time. These days, what professional indemnity insurers are saying to me is that there's been a switch. And these days, more and more negligence claims arise as a result of poor communication. And remember, communication is a two-way process. It's not just me talking to you about CQS today. It's hopefully about you giving me some feedback, firing questions, asking for information. That is a way in which I can tell that you've got some of the points that I've made. Well, exactly the same principle applies with clients. You can send a brilliant 40-page report on title to a client, telling the client everything and anything they need to know about the title that they're acquiring. But unless the client understands it, unless the client reads it, unless the client engages with you as a consequence of what you've sent, we've really failed. And therefore, it's important, in my view, to make sure that we are ensuring that clients are effectively communicated. And that's one of the big things that is important. With regard to people management, then, it's not just people management with regard to clients, it's also managing our staff. And there's some interesting changes with regard to CQS in that regard that I'm going to share with you in a moment or two. Interestingly, when you look at the new guidance, sort of there's a lack of emphasis on supervision and operational risk management. And a lot of people have commented on this. And the point I would emphasize is just because it's not sort of focused or not sort of highlighted doesn't mean it no longer is an issue. Supervision, operational risk management are very important as part of the conveyancing process. Operational risk management is interesting in that what we're seeing is a sort of drilling down relating to operational risk management. So looking at risk, assessing risk, and then looking at it on a sort of file by file basis rather than creating sort of strategic views relating to risk management. So when we talk about operational risk management, we really do talk about day-to-day activity with regard to fee earners and files. Again, I'm just going to have a look because there's another question there. Okay, that's fine. Good. Sorry about that. Pushing on. New provisions, requirements for registers of plans and policies. Why? Simply so that CQS, when they come and assess you, which they will, can see that we're not just creating plans and policies and having a lovely ring binder or having a lovely file on our computer system that everyone can look at if they're interested, but showing that we're reviewing, that we're monitoring what we're doing, that we have plans and policies, but that we are utilizing data to change them, to update them, to make sure that our fee earners share the plans and policies that we've got. So the idea of a register is that we've got opportunities to undertake reviews to make sure that the documentation, our plans, policies and procedures are sort of working documents. Very important. Secondly, as far as induction processes are concerned, making sure that when we're onboarding clients, we're doing all that's necessary to make sure that clients are properly onboarded and that we're onboarding the right sort of client in connection with the right sort of work. Now, I'm going to be sharing some views with Lisa a little later this morning and discussing how InfoTrack can help us with regard to onboarding, but just be aware of the fact that InfoTrack have some very useful products that will assist, that Lisa will tell us about, hopefully, before we finish this morning. AML risk assessments on every file. So it's not just a question of looking at AML issues when we're onboarding the client, but looking at each and every transaction. And money laundering is an issue and has been an issue for years and will continue to be an issue for years. Why? The residential conveyancing process is a beautiful tool for the criminal to wash dirty money and to then have funds from you to them that they can use legitimately. So ever since I've started training, ever since I started residential conveyancing, money laundering has been an issue. Money launderers, criminals have got more and more sophisticated. Fortunately for us, the systems and processes that we can use that are available to us to prevent money laundering have increased. Again, you're not expected to work for MI5. You're not expected to sort of spend 90% of your time being concerned about money laundering. It's a question of awareness when we're onboarding clients and awareness throughout every transaction, every client and every file. The same principle applies with fraud. Again, people ask me, what's the sort of latest thing relating to property fraud? And the answer is I don't know. And I don't think anyone knows. All I can tell you is during COVID, during lockdown, with people working away from home, when people were exceedingly busy and under pressure, bet your life fraudsters saw opportunity. And bet your life, fraudsters have been very sophisticated, very clever with regard to the systems and processes that they're utilizing to perpetrate fraud for their own benefit. The bad news is we will only see what fraudsters have been up to normally when there's a recession, when lenders start repossessing properties or when the property market becomes active due to decline. And then we see people sustaining loss, and then we see claims being made. But seller identity fraud is a major issue. Requiring a fraud risk assessment on every file is important, and critically, making sure that fee earners are aware of two things. One, that a risk assessment doesn't mean that's it, problem solved, and we don't have to worry about fraud going forward, that we should be aware of fraud throughout the transaction. When we're taking sellers on board, we should be checking their contact details against addresses for service from the land registry. And if we look at cases like Purensing and Dreamvar and Gondona and all of these other cases, what you tend to see is the court saying there might not just be one piece of information that's provided to a fee earner that sends alarm bells ringing. There could be a drip of a number of things said, a number of omissions, a number of things that don't quite tally or seem right that get alarm bells ringing. And the important thing is that fee earners are aware of that. Fee earners are aware of the need to ensure that they are constantly alert to fraud. So it's not just when we're onboarding clients, are we checking signatures? Are there things that are being said to us that are strange? And are we talking to colleagues to get opinions or views on the suspicions that we have or the fears or concerns that we've got as a consequence of things happening during the life of a transaction? So again, we'll have policies relating to fraud, we'll have policies with regard to how we onboard clients, but we've got to have individual risk assessments on each file, not just on each client. SDLT is an interesting issue for residential conveyancers because it's become more complex. We've got reliefs, we've got all manner of surcharges potentially applicable. And I think there are a number of things with regard to SDLT that we need to be aware of. One, there's nothing wrong in getting specialist advice relating to SDLT in connection with conveyancing transactions. Two, it's important that clients understand the limitations that a fee earner will have relating to that advice. So we should be able to explain to clients the risk of SDLT surcharges or reliefs being available. explaining what those reliefs and surcharges are, and advising on a sort of standard residential transaction what SDLT liability our buyer client is likely to incur. We've also got to be careful about making sure that we're extracting the correct information from our clients so that we can give basic advice. But the important thing with regard to SDLT is that fee earners are aware of surcharges and reliefs, aware of the fact that we might be involved in a complex transaction, mixed-use property, for example, large property that comprises of more than one home, large houses where there are extensive grounds, are they residential or commercial, that might require opinions or views from third parties. On the issue of dealing with leasehold matters, I mentioned this in my introduction. It's important to understand that the CQS is urging assistance, urging that we give clients guidance on the bigger picture with regard to leasehold transactions, the distinct disadvantage that a leaseholder has as opposed to a freeholder, an understanding of where additional advice can be obtained relating to leasehold matters, and the fact that there are changes afoot with regard to leasehold that clients need to be aware of. The new provisions also deal with the issue concerning lenders, and one of the things that's quite interesting is the need to review the lender's handbook and your instructions before you exchange contracts. So there's an obligation there to check the position with regard to your lender's instructions before exchange in case those instructions have altered, so that you can react and deal with whatever the changes are. I did some research on this, and one of the lenders, I think in 1 month, made over 100 changes to their instructions. Fortunately, all were relatively minor, but it's important that you check, that there's a record of when you've checked and what you've identified relating to change. And again, just highlighting the fact that, you know, we've got standardization of process. We've got fee earners and members of staff that understand the conveyancing process, but they've got to be aware of what they don't know, when to ask questions, when to seek assistance and guidance. Before I leave this slide, an important point to make to you. I was talking to council earlier this year about reporting issues to lenders. And the discussion really went about the fact that conveyancers will tell lenders about issues that they've identified in connection with title. And a lender will basically say, well, thanks very much for telling us, but what we'll do is rely on your professional indemnity policy. Is this a good and marketable title? Is this adequate security for us or not? And what council was saying is, as a consequence of that, some firms aren't asking lenders anymore on the basis that it's a futile exercise. But his view was, and I tend to agree with it, you should ask. Even if you don't get a response, or even if you don't get a response that's meaningful, at least you've asked the question, at least you've drawn it to the lender's attention, that might generate a defence in connection with a negligence claim at a future date. Again, yeah, Zara, you raised another question. Yeah, we'll look at that one at the end. Thanks for that, Zara. Okay, confusion. The new guidance doesn't lay a lot of emphasis on cost estimates, or fee earner status, or the need to comply with the SRA codes of conduct and CPMS. Well, the point here is we still have to comply with general law. Therefore, we've got to be transparent regarding costs. We've got to be transparent with regard to who's dealing with matters. On the issue of cost estimate, I've got a number of bees in my bonnet relating to costs. Firstly, don't win business on the basis of being cheap. Don't buy business, in other words. Frequently, when you do that, you're attracting work that isn't profitable, obviously, clients that are difficult and looking for the cheapest conveyancer to do the job for them. And what they'll do second time around is just do the second exercise. So there's very little client loyalty as a consequence of that type of acquisition. If you are undertaking work, make sure that if you're looking for a differential between your firm and others, that it's a differential other than with the cheapest. The other point with regard to costs, if you're getting work referred to you, if you're winning work on the basis of fees and things change during the life of the transaction, you are entitled to revise your cost estimates, as long as you notify the client as to what those estimates are now going to be reviewed to. You can't just simply, at the end of a transaction, bill a client more on the basis you've done more work. But you can say to a client, look, Mr. Client, I'm going to have to do some additional work here for you. And therefore, if I'm going to do that, I'm going to have to charge for it. And then it's the client's call as to whether or not they want to proceed or not. And the other thing I always say to fee earners is where you can't charge, at least let clients know that you're doing extra work. Because if nothing else, you're generating a bit of goodwill for the client as a consequence of what you're doing. Pushing on, if I can. If you look at the new CQS guidance, there's a number of things that I think are important. First of all, personnel includes part-time staff and consultants. So during the summer months, if you've got locums doing residential conveyancing work in your department, are they aware of the practices and procedures that you've got? Are they aware of the changes to those practices and procedures that you've recently made? You might have a locum that comes in on a fairly regular basis. Well, again, if we've reviewed our CQS practices and procedures, is that locum aware of what that review is? And the same thing applies in connection with part-time staff. Everyone that's undertaking work on a file should be aware of what we're doing with regard to our practice. As far as plans are concerned, a need for mapping. And what I mean by that is a need for sort of review, a need for sort of change where change is appropriate, and the need to ensure that all staff are aware of what those changes are. And the key seems to be a transmission between creating policies at sort of management level and making sure those policies, those practices are put into practice. As I highlight here, procedures, descriptions that are acted upon is the key point that we need to be aware of and we need to be addressing constantly. As far as people management is concerned, hey, some good news, training. That's good news, isn't it, for everyone? The idea of training with regard to changes in the law, changes with regard to CQS, making sure that we understand how we communicate effectively, not just with clients, but with banks, the use of electronic formats for signatures and for documentation. So keeping people up to date with regard to law and procedure, keeping people up to date with regard to CQS generally, our practices and procedures, and using data to review what we're doing relating to training. So if we're getting lots of new instructions in connection with residential leasehold issues, and we don't have the staff to deal with residential leasehold transactions, then we'll have data coming into our systems that will enable us to make some decisions. Do we start declining residential leasehold work? Do we upskill some members of staff, or do we take on new recruits to do it? So the idea is, with regard to people management, we have people to do the work that's coming in, and we either choose the work that's coming in so that our people are not overburdened, or that we recruit more and train more to ensure that our staff are more efficient, and that we're looking ahead all the time at changes in the law, or what changes in practice, or changes with regard to what our firm is doing, and making sure our staff come along with us on that journey. Learning and development policies, sort of similar thing, isn't it? Supervision and management training. And again, soft skills for conveyancers, dealing with difficult clients, dealing with time pressures, dealing with working from home, and the stress and intensity of the work that we've all got to do are all important issues to be addressed and to be considered as part of our learning and development policy. Again, as far as this is concerned, we're reviewing what we're doing relating to training, looking at the work that's coming in, looking at the levels of experience that our staff have, and seeing what we can do to improve their lives and improve the quality of their work. Taking a step back and again, using data to see what we can do. So are we getting a number of complaints from clients about particular issues? As far as our claims history is concerned, are there lessons to be learned relating to what's causing claims? Interesting statistic, the average value of a negligence claim against a conveyancer between 11 and sort of £17,500, not vast amounts of money. And most common types of negligence claim is a failure to do the simple things well, not a complex transaction that a firm has never seen before, or a complex transaction that's highly unusual. What tends to happen in those circumstances is the fee earner takes a step back, has a look at it, speaks to colleagues, and proceeds very cautiously. Most claims arise as a consequence of something that you're very familiar with, but due to time pressures, due to something happening with regard to the file, the eye is taken off the ball, as it were, and errors arise as a consequence. With regard to risk management, we need a number of things. Firstly, compliance plans, obviously. Risk registers, obviously. assessment of risk management roles, and communicating risk information to fee earners, so that fee earners can then have a risk sort of action plan for individual files, so that they can determine the exposure or the vulnerability to the firm in connection with this particular transaction. So again, it's a sort of switch from this sort of office manual that we've got that we need for CQS into everyday practice, making sure that all fee earners, all support staff are aware of indicators of risk and making sure that they understand and appreciate how that risk is then communicated up or down the line of management as appropriate, and making sure that where we have risk information, we're recording data and then using that data for changes to our practice and procedures. Moving on, if I can, some other things that we need to be aware of. Firstly, managing instructions. So where's work coming from and what sort of work is it? And is it the sort of work that we want? So if it's high risk work, then have we got the appropriate fee earners to deal with it? If it's new types of work, are we training our staff so that they can be accustomed to what that work involves? And when we talk about managing instructions, I also think we talk about managing expectation. Do clients understand what we're going to do and also what we're not going to do is one of many themes of a lot of my talks, on the basis that making sure that clients understand what the conveyancing process is and what our role is critical to prevent claims, to prevent complaints too. Listing and allocating work types, so recording the types of work that we're getting. And I don't just mean it's a residential leasehold sale or a leasehold purchase, thinking about geographical locations, looking at the type of client that's giving us the work, and just assessing if there are lessons to be learned from that, or things that we can do to improve levels of service. I often say to people, you know, it's a dangerous thing to try to look for new sources of instructions and new types of client. Far safer and far better to furnish and provide for the existing types of clients that we've got. So if we're a high street practice, you know, never advocate that we try and reinvent ourselves as a conveyancing factory. A, it's going to be expensive. B, there are good conveyancing factories out there that have been out there for many a while and that are going to be better at it than us. And therefore, why not refocus on the sort of work we're currently getting and try to get more of the same? Identifying transactions that won't be taken on, mixed-use properties, properties with high levels of risk relating to fraud. Making sure that we detail and review specific risks relating to a transaction and also generic risks. And a need for key date monitoring. And an important point to emphasize here, it's not just a question of monitoring the last day to do something, but making sure that our processes highlight a date before the end date, as it were, so that we've got time to react, time to assess, time to deal with issues. Again, putting my negligence claim hat on for a moment, frequently I see negligence claims arising on the basis that all of a sudden it's right at the last minute, we've got to do something. We've got to exchange contracts at 12 o'clock today, otherwise the transaction's off. We've got loads of other work. We're under a great deal of time pressure. We don't have time to do an audit of the file. We exchange contracts and then find that something is amiss. It's that sort of thing that is the problem. Giving ourselves time to react, building in time to deal with problems is useful. And you're all going to say quite rightly, well, hang on, Ian, that's great. But when you've got 60, 70, 100 clients all sort of shouting and screaming for your time and attention, it can be very difficult. Time management can be difficult. I agree. What I would say, however, is that CQS is designed to try and ensure that we focus in on allowing us time for the important decisions and the important processes. Key date monitoring important. I advocate that we're building in time to enable us to deal with key issues and key dates. We're not dealing with things right at the last minute that frequently. From time to time we have to, but doing it on a regular basis is dangerous. Other things that are important relating to CQS and changes to CQS are being aware of conflicts of interest and managing conflicts of interest. So again, the idea of conflicts between clients and the client's requirements, and conflicts of interest between the firm and the client, being ensuring that our fee earners, our members of staff, are aware of what we can do to check for conflicts of interest, and making sure that we've got systems and processes that are sufficiently robust. Training supervisors as to how to supervise, making sure there are systems in place that make sure supervision is effective, but being aware of the fact from time to time we could have an unusual transaction that requires us to go out of the standard process to try and ensure that the transaction is properly conducted, and that fee earners, and indeed those that are supervising, are comfortable with their roles. Making sure that we have cover for fee earners that are aware of our systems and processes, obvious, and file reviews. Interesting point this, I was listening last week to an American psychologist who was saying, when we look at reviewing and client reviews, etc., a number of points which are basically very obvious, but were sort of useful to have reminded to me. Point number one, good reviews are not as useful as bad reviews, on the basis that a good review telling you how marvelous you are is great for the ego, great for your sort of self-esteem, great when you're going to talk to a line manager about a pay rise. But as far as your systems and process are concerned, so what? You're good. Client coming back, or someone else coming back, or an internal review determining that there's room for improvement, far more useful, because we can put plans afoot, we can change our practices and procedures to make things better. So when we're looking at how we review files, I think the key is to try and extract the files where things haven't gone so well, where there have been problems, where there have been issues, either from the client perspective or the perspective of the fee earner, or the supervisor, manager, or the firm itself, so that we can have a look and learn lessons. And then I think the important thing CQS changes recommend is the fact that that's shared, that there is data, that there are reports that are useful, not just for the fee earners involved, but for those that weren't involved and perhaps weren't even aware of the problem or issue that arose. Money laundering, requirements for risk assessments on each file, as I mentioned. Everyone understanding the role of the money laundering reporting officer and making sure that we're aware of money laundering throughout the transaction. And again, when we've got members of staff that are onboarding clients, when we've got fee earners that are dealing with onboarding clients, just to be aware of things like the payment of a deposit early by a buyer, and then asking the deposit to be returned to the client as a consequence of a transaction not proceeding, is again a very easy way of washing dirty money through the conveyancing process. So it's not just the sort of purchase of a property courtesy of criminal activity. And when we talk about criminal activity, be aware of things like COVID loans, bounce back loans, benefit fraud, etc., enabling clients to amass funds and then enabling assets to be acquired is money laundering just as much as the bank robber using the £500,000 that's kept in the wardrobe to purchase a property through your firm. So having robust practices and procedures, reviewing those procedures on a regular basis, important, and something to be addressed by your firm, and something that CQS guidance now requires you to do on a file-by-file basis. Property and mortgage fraud. I've spent the last sort of 4 or 5 years explaining to practitioners the risk of fraud and highlighting in particular seller identity fraud, but also warning fee earners that fraudsters are sophisticated and clever, and that we only see new types of fraud when that fraud is sort of brought out into the open as a consequence of prosecutions or as a consequence of someone sustaining loss and then claims being brought against conveyancers. So current issues relating to fraud, obviously seller identity fraud remains an issue. Cyber fraud and the ability of fraudsters to hack your systems. So making sure that you've got robust processes to protect those systems. Electronic signatures theoretically remove or reduce the risk of fraud. But again, awareness of the fact that there may be opportunities for fraudsters as a consequence of new electronic client verification, electronic signature systems. So do you have systems in place to monitor and assess the robustness of platforms that you're using for those purposes. Do fee earners understand the sort of safeguards that are in place, not only internally within your organization, but externally in connection with the platforms that are being utilized? Other things to watch out for relating to fraud: mortgage fraud. Again, fortunately for us, mortgage fraud is often going to be undertaken before we get involved in a transaction. But again, Grondona is a sort of famous case where a seller perpetrated mortgage fraud courtesy of her and her partner selling a property. The solicitors acted for both parties, and in addition to that, were negligent with regard to the conveyancing transaction. A pretty sorry tale, to be honest with you. But again, just highlighting the availability of mortgage fraud and the fact that in that case, the solicitors, in acting for both parties, buyer and seller, both of whom were involved in the fraud, created a situation that meant that liability for negligence couldn't really properly be defended, no matter what. High-risk file management, important, ensuring that there's supervision, ensuring that the appropriate fee earner is dealing with the matter, in my view, is critical. I mentioned SDLT at the start of my presentation, making sure clients are aware of the position relating to SDLT, the fact that you're dependent on the client providing you with information to assess their circumstances to determine SDLT liability, reliefs or surcharges that could apply, making sure clients are aware that where SDLT is unpaid or incorrectly paid, the HMRC can recover costs, can recover interest, and can recover surcharges as a consequence of errors that are made or misinformation provided. Making sure that there are file checks, and this is a very important point, I think, that applies really out with CQS. Whenever you're dealing with SDLT, make sure that there is on file a record as to how a view or stance has been taken relating to SDLT liability. So if HMRC come along and you've made an error, at least they can see this is a genuine error that's been made and isn't some form of evasion or fraud. Watch apportionments on residential sales. Have you got evidence to support an apportionment where particularly SDLT is reduced or SDLT eliminated as a consequence of an apportionment? And making sure that clients are signing documents to confirm that they're first-time buyers, that they don't own property abroad, that this property is being used for a commercial purpose or mixed-use purposes. So again, you've got information from the client that you're relying upon in connection with information that you're subsequently submitted or submitting to HMRC. Leaseholds, one of my favorite subjects. The SRA back in 2017, the Law Society back in 2017 highlighted that conveyancers were focusing in on the transaction, the lease, making sure that clients were aware of each and every provision within the lease and how it could impact on the client as a consequence. The important thing to be aware of is that is still as important as ever. The new guidance from the CQS highlights the fact we should be warning clients about the term of the lease, issues relating to ground rent, issues relating to service charge, but also that we should be explaining to the client the distinct disadvantage that residential leasehold ownership provides. To that end, there is some useful guidance on the Leasehold Advisory Service website, a leaflet called Buying a Leasehold Flat, 10 Things You Should Check. And ARMA, the Association of Residential Managing Agents, has some more guidance called Living in Leasehold. So I think either explaining to the client the radical difference between freehold and leasehold ownership is important, using external resources to assist or back up what you're saying is important. And I think the other thing that's important is to make sure clients are aware of the statutory protection that's out there to protect leaseholders. So the requirement that service charge in order to be payable has to be reasonable. The requirement for a landlord to ensure that leaseholders are advised of their statutory rights to challenge service charge before service charge becoming payable. Ground rent demands having to be in the appropriate statutory form. The right to collectively enfranchise. Applications under section 35 and 37 of the Landlord and Tenant Act 1985 to vary defective leases. The right to extend leases, the right to manage, the right of first refusal. All of these things need to be explained to clients. Now, a word of caution. If we're going to provide all of that information to clients, our report on title is all of a sudden going to become a huge document. I'm not advocating that. What I am advocating is when we become aware that our client is buying leasehold property, to make sure that we're providing our clients with choice or sources of data and information, so that clients can be fully armed if they're interested in what leasehold ownership is all about. On the issue of term, I would always warn a client where the term remaining is less than 90 years of the potential problem where the term becomes less than 80 years. With regard to ground rent, I'd be warning clients who are buying new properties at the moment that ground rent is being abolished, but that landlords might be looking to recover what would have been ground rent into service charge, advising people that are taking assignments of old leases. There's now a dual regime relating to leasehold property, new properties where there's a peppercorn ground rent, old properties where the ground rent may well be the same as previous and will be a monetary amount payable to the landlord. Service charge, particularly with high-rise flats, the fact that service charge can increase, will continue to increase with regard to fire safety measures. Insurance, again, the idea in high-rise flats that insurance premiums are sort of stabilizing, I think is dangerous. Insurance premiums will continue to rise until the market stabilizes. Clients need to be aware of all of those issues. Taking an assignment of a lease, taking a new lease and being provided with 3 years service charge accounts or estimated service charge accounts, my attitude, so what? It's not going to give you data as to what the service charge will be going forward. We could spend a day talking about residential leaseholds and the bigger picture. The key is provide clients with information and resources, make sure that clients are aware of the disadvantage between freehold and leasehold ownership. The government keeps threatening all sorts of interesting things. I was just reading at the weekend there, you know, the idea of launching or relaunching common hold. Well, some practitioners will think that's sort of dead in the water. I don't think it is. The government seems to have the same old mood music with regard to let's think about relaunching or reintroducing common hold. More on that, perhaps on another occasion. I mentioned data analysis. Using an annual assessment of data that your firm has internally and devising systems and processes for its use. Can we assess and revise risk on the basis that's what's happened in the last 12 months, last 6 months, or the last quarter? So are we using data not just on an annual basis, but using it on a rolling basis to see what's happening with regard to the work that we're doing and see what's happening with regard to particular aspects of our conveyancing systems and processes? Client care with regard to onboarding clients, make sure clients are aware of what we're going to do and also what we're not going to do. Be aware of client confidentiality. Again, I remind practitioners all the time that if I'm your client and I send you an email saying, look, we can't exchange contracts this week because I've tested positive for COVID and I'm not very well. If you ping a copy of that email to the other side explaining why we're not going to be exchanging this week, then that's a breach of my confidentiality unless I've authorized you to send that email to the other side. So again, be careful with that. Be careful about communicating effectively. When we're writing to clients, when we're sending reports on title to clients, asking clients questions, are we saying to the client, have you read this? Have you understood it? Do you have any questions? When we're referring to third parties, are we choosing those third parties carefully? Are our clients aware of why we're referring to third parties and what choices the clients have? And again, one of the things interesting with regard to changes to CQS is this point about clients. The conveyancing process, the mechanization of it, the changes to procedure and the standardization of that procedure means that clients all of a sudden lose their personality. And I think the CQS guidance is saying that can't be right. So emphasizing how we deal with disabled clients, but also emphasizing what we do or what we should do with regard to clients generally. Moving on, if I can, because I'm conscious of time for questions. I mentioned in the slide here a number of things. As far as the clients are concerned, CQS is a standard. It is a procedure. It is a benchmark. that provides benefits for clients. As far as the CQS is concerned, it emphasizes handbook compliance and making sure that we're aware of changes to the handbook. It makes sure that we're reporting to lenders and that we understand that as far as lenders are concerned, even where a lender is not going to give us a firm view one way or the other as to what happens next, they should have issues reported to them relating to the file or relating to the transaction. Complaints. We should be being aware of what complaints are. As far as complaints are concerned, the one thing that CQS sort of emphasizes is that we should have complaints processes that don't of themselves generate complaints. Have a look at the Legal Ombudsman's website as to how to deal with complaints and make sure that fee earners are aware of steps that can be taken to prevent complaints happening. Again, back to data. So in the last 12 months, what type of complaints have clients made? Let's have a look at them. Let's come up with processes to see what we can do to prevent those claims or those complaints arising in the future. Making sure that we've got evidence of client satisfaction and dissatisfaction. Making sure that we're selecting instructions carefully and making sure that we're dealing with conflicts of interest I've mentioned to you. Before I finish, some key issues that I think are important that we can extract from the changes to CQS guidance. One, the giving of undertakings, making sure that fee earners are aware of the significance of undertakings. I would go further than that, having a sort of a precedent bank of undertakings that the firm is happy to give, making sure that fee earners are reluctant to give oral undertakings, making sure that we have systems for live, inactive and closed files, particularly inactive files. Why are there delays? Let's look at how long it's taking us to get conveyancing transactions from onboarding a client to closing the file. And let's have a look at fee earners' performance to see if there is information or things that we can extract from that performance. Looking at how we store documentation to make sure it's accessible, but yet preserving confidentiality, and making sure that we manage closing files properly. On closing files, our clients are aware of their ongoing duties and obligations. On a purchase, for example, is a client aware of the need to ensure that where a defective title insurance policy is taken out, that the client is aware of their duties and obligations to the insurer, is aware of their duty to ensure that addresses for service at the land registry is kept up to date, where a deed of trust is being prepared in connection with co-ownership. The client is aware of what is necessary relating to the transmission of information to you or whoever they want to instruct about the deed of trust requiring varying. All of these things need addressing. To conclude in my presentation, if you have any questions or queries, drop me a note at the email address shown on slide. What I'd like to do now, I know we've got a lot of questions, but I'd like to talk to Lisa if possible. Lisa, thank you for joining us this morning. Lisa, one or two questions for you in connection with InfoTrack. I have emphasized the fact that InfoTrack is there to help with regard to the conveyancing process generally, but I'm quite interested to learn about your views in connection with some of the things I've mentioned and some of the products that you think might sit comfortably with fee earners, with solicitors and conveyancers to assist in connection with some of the changes that I mentioned. So if I talk about onboarding clients, what sort of product have you got that can assist firms in connection with onboarding?
Yeah, thanks, Ian. Good morning, everyone. I'm just going to share my slide and share my screen even and talk about onboarding in particular. For those of you who don't use InfoTrack already, I know many on the session today do, but for those who are seeing InfoTrack for the first time, let me just briefly explain what you're seeing on the screen here. InfoTrack basically is a web-based solution offering end-to-end digital conveyancing solutions, allowing you as a conveyancing team to gather and submit all elements of data that you need typically on a residential transaction, whether it's a sale or a purchase, or whether it's a commercial matter for that reason. So you will see on the top of the screen, you can see that what we've put together on the web-based solution is a workflow going through the various stages that you need to gather and submit data. So you will see here that we start with onboarding. So we call our onboarding tool an electronic client onboarding service, abbreviated to ECOS. And you will see that AML lives separately there as well. So you can do your electronic anti-money laundering searches with us, meeting the 5th directive. Now, when it comes to onboarding, every law firm has their own process of evaluating their client or their prospective client. And sometimes, excuse me, the onboarding process differs from client to client. So the solution we have in place meets all needs. You can do all of our onboarding facility or pick and choose the elements that you need to onboard your clients at that particular time. So just to briefly explain the onboarding process, you will click on ECOS and you will fill in a few details which will allow you to onboard your clients electronically. Okay, so you will see here that it's asking for your matter number. These fields will be populated if we're integrated into your case management system, but it just takes a few seconds to get the details in place. And then you will see from the onboarding tasks that onboarding with InfoTrack doesn't just lend itself to onboarding conveyancing clients. It can be used firm-wide just for verification on a litigation case, for example, or a family matter. But considering we are talking about conveyancing, of course, you can onboard your client from a sale perspective or a purchase perspective. You will see here as well that you can actually send out your protocol forms with us. So these are the Law Society Property Information, Fittings and Contents form and so on if you are dealing with a sale. This just means that your client can receive these electronically, fill them in electronically and not sign off on them and send them back to you until they're 100% complete. So it will save you time in that chasing that you have to do afterwards. So you can onboard with the TA6 forms, TA10 forms and so on. You'll also see you've got a few options here with VOI, which is verification of online identity, where your client identifies themselves via taking a selfie, which is a biometric selfie, and taking a snapshot of their passport or their driving license. And the biometric testing that goes on there just make sure that that person is who they say they are compared to the selfie and the document that they've taken a snapshot of. We've also got VOI Plus, which includes an enhanced identity check as well, all in one, as well as VOI and VOF. And VOF is verification of funds. So if your client is an online banker, they can send their documents to you via this link here. So their bank statements up to a year's worth, not just for one account, up to 3-4 accounts if the need may be. So you just basically enter in a few details here of who your prospective client is. Also, we give you the ability to update your terms here. So if you want them to sign your client care letter, your terms and conditions and so on, you can actually update the documents and attach that to the request as well. So you get those signatures right from the off. And then simply an email, which can be bespoke to your wording, goes off to your client, and your client will then be asked to actually complete online. So this is just a dummy of the client email that your client gets, which will ask them to fill those details on a portal. Now you can see here, we can brand it to your branding, your color schemes and so on. And when your client goes off to the web to actually complete this process, they will be asked to send an access code to their phone, which will allow them access, and they can complete everything securely. Step by step, they will be asked to sign off the initial documents and so on. And also, as that happens, you receive the documentation back fully. That's stored in InfoTrack for you, so you've got that documented evidence. And if you are integrated into case management with us as well, it will drop straight back into Matter. So this is web-based, so your client can fill it in anywhere. But just going back to that screen here, the VOI Plus option that we have as well covers safe harbour guidelines, which is the Land Registry Safe Harbour guidelines. So if you are following those guidelines, which are not mandatory, but they are out there and a lot of firms are adopting to safe harbour, VOI Plus will give you that safe harbour assurance as well. Now, ECOS is varied with InfoTrack, so the option that you choose, we can bespoke to your needs. If you prefer that your client fills all of their identity documents in via an app, we actually supply you with a branded app as well to allow them to do that. But safely assured, by using ECOS via us, you meet those requirements via the CQS criteria straight away. And of course, we've got AML there independently as well. If you are still meeting your clients face to face, you can just do a full AML check as well as part of your procedure. So hopefully that answers your question, Ian.
It does, thank you. Yeah, that's great. Thanks for that. Another question really just about, practice and procedure and some of the things I was saying about, changes to practice and procedure. What's InfoTrack got for practitioners to help them with regard to ensuring sort of compliance with best practice and with compliance with CQS?
Yeah, there's quite a lot on the website, and we do work very closely with Law Society on a lot of the products that we develop and put out there, really. And so we are forever making sure that by using InfoTrack, solicitors, yourselves on the session today are protected. Basically, all of the conveyancing process, you can use this for the whole conveyancing process or part of it, but it just means that none of the forms being sent out via us or the templates being completed will ever be out of date. It's future-proof, really, so you don't have to worry about how your report and title is compliant, are you meeting all the guidelines, you're inserting the right clauses and so on and so forth. We do that for you. So nothing within the transaction process will be deemed to be insufficient if you are using InfoTrack. Basically, it is future-proof. So touching on a few of the products and a few of the bits of criteria that you do need to meet with CQS. For example, we have full integration with Land Registry. So when you're ordering your documents, your day-to-day documents, OS priorities, for example, one of your key dates, one of your compliance criteria on CQS is to manage key dates. So refreshing of the priority searches is vital. If you miss one, you've got to obviously go through the process of re-engaging on that offer. But when you order OS priority alerts with us, you will automatically receive alerts when they need to be refreshed. And if I just look over to the right-hand side of my screen, you can see a calendar over to the right. So this just basically informs you via email when you need to refresh, but a calendar is there as well, not to leave it till last minute, but telling you what's going to happen or what needs refreshing during that week. So if your colleague is off who needs to refresh that document because they ordered it, InfoTrack is a firm-wide account. So everybody can acknowledge these alerts, refresh priority documents, and you will see there as well, this relates to AP1 requisitions as well. You can monitor all of those via us, so you can answer requisitions when they need to be answered and never miss a deadline. But going into two specific points, which you drew attention to, Ian, of course, SDLT, keeping people informed on what they need to do with SDLT. You can compile, submit, and manage the Form 5 through us by using our SDLT feature. But when it comes to reminding clients what they need to do from a clause point of view, that's often put into the report and title. And likewise, when it comes to leasehold information and the importance on leasehold information that's within CQS now about reporting on terms, ground rent, service charges, and so on, our property report, which basically is a one-stop or one-screen place to compile your property report, allows you to report on title no matter what the tenure. So you will see here that if it's a freehold, new build, you can actually compile your report on title with us. But of course, we cover leasehold as well. So just in short, when you order your documentation through us, everything is digitized. So your report on title becomes literally 75% complete as soon as you run the report on title, the property report. So it just saves you having to worry about what clauses you put in, what property you're dealing with. The system is dynamic because you've ordered certain aspects of your searches, your land registry documents, your lease document, and so on through us. We digitally pull off all the information that's relevant to that property. So if I just basically pull up an example of a property report, and this is a leasehold one, you will see that, again, this is in your branding and so on. But you will see that when you create the property report through us, and I'm just going to draw your attention to the table of contents, you will see that it covers everything that you need from a lease detail point of view, ground rent, service charge, and so on. And when it comes to reporting on SDLT, of course, every property report will cover off the clauses that's needed for stamp duty as well. If it's a Welsh property, of course, it will cover the LTT standard text and so on. But we've built this product to take the heavy lifting away from you guys. If you order searches through us, they will be pre-populated to cover the search element, the e-cost documentation that if you use us for onboarding will pull through to here. So you've got everything at a glance, and the library of text that we've put behind this will mean that you've got a report in 15 minutes, basically. Leasehold might take a little bit longer than freehold, 15 minutes one, but nevertheless it's there. But if I just show you, if I just quickly scroll down, just bear with me while I scroll down to page 8, where we can actually look at the wording that we actually put in place when it comes to leasehold. So you will see there, for example, service charge, all the documentation, all the wording that you need around that particular lease for that particular property will be digitally placed into here directly from the lease. And we fill that out with compliant text, because we know this is a legal document. So this is being signed off by the Law Society to help you get that content right specifically for that property. So it will take the lease, it will scan it, and it will pull through the relevant details needed. Likewise, as I mentioned, for the SDLT as well. So that's another benefit that you get when using InfoTrack. Okay. So hopefully that answers that question there, Ian.
Yes, thank you, Lisa. Lisa, I'm just conscious of time, and I know that there's some questions. So if we may have a look at some questions, Faye, before we sort of beat the retreat. While we're doing that, Lisa, if people want to know more, then obviously they can contact you and your colleagues at InfoTrack. And again, I assume that the sort of staff at headquarters and staff on the road to sort of talk to prospective clients, etc. Yeah,
100%. And just as I finish this off before we go into questions as well, I just want to and these slides will be sent through to you guys as well, just to let you know that from the core practice management standards, which Ian's touched on today, and what we've just basically done is just looked at each section of that CPMS document and just broken down within each section which products and services and solutions available through InfoTrack will help you meet that criteria in each section. So you can see there structure and strategy, financial management, information management as well, people management as well, which Ian spoke a lot about. From a training perspective, InfoTrack, we work with induction programs across the board with our clients. If you get new users, we can get them up and running with InfoTrack and take that pain away from you in getting that built in. So we were often part of induction programs, but probably the biggest section is risk management. So all of those aspects there help you meet the criteria. And I think it was Adela who asked a question about lender handbook. You have got the lender handbook available through InfoTrack. And that will allow you to troll through part 1, 2, and 3, and so on, and find the policies that are needed. But as Adele does, she has set herself up with alerts with the various lenders, where we email you automatically the document as to how it's changed, what the changes are, and that does act as proof and documentation. And everything lands back in InfoTrack as well, but you do have that document of the change within there. LMS integration as well for lender participation. We integrate with your LMS portal. So it just means that when you order your priority searches, do your AP1 through us, we update your LMS portal automatically for you. So all that managing of all the emails and everything else that you have to deal with on a day-to-day basis, they disappear. We take care of that. And it goes on to all of the sections basically. So you can actually get in touch with us via that email address there, a little bit about InfoTrack. But as Ian says, if you need to get in touch with us direct, there are email addresses. That's who we are, a beautiful little picture of us both, so you can remember what we look like. But do get in touch direct. We are always here to help. So yeah, that's it.
Thank you very much, Lisa. Thank you. Faye, as far as questions are concerned, I'm conscious of time. Are there any sort of questions that sort of immediately come to mind or immediately require our attention? Or is it okay if we just deal with them, anything that comes in that's InfoTrack specific that Lisa and your good self deal with, and anything that's sort of transactional wise or anything arising from said, I'm happy to deal with by email, and again to share with you so that you can have share with delegates my response to any questions that arise. I think that might be a sensible way of dealing with things.
Okay, well, we have had a few questions, so if
Yeah,
you've got
great.
a couple of minutes, we can get
Yeah.
through a few. And then what we'll do, a couple of people have asked if this is going to be recorded. I've already mentioned it, but just to confirm, yes, we are going to send a recording of this webinar along with Lisa's slides and your slides.
Yeah, brilliant.
Everybody has a full picture. So just quickly, I've got a question for Lisa. Does the InfoTrack leasehold report on title highlight the disadvantages of leasehold, which Ian was referring to?
Yes, it does. In the library of text that we've put together, we automatically insert that text if it's needed for that particular property.
Lovely. And another quick question for you, Lisa. Are the new online AP1s available through InfoTrack?
Yes, they are. Very good question, that one, actually. We've provided AP1 solutions with InfoTrack now for coming on to 6 years, and they are fully digitised. So the November 2022 deadline, where everybody has to submit their AP1s digitally, by using InfoTrack, you tick that box instantly. And the beauty about it as well is you can compile. It's 95% pre-populated if you use our other services as well. So it's quicker to put together an AP1. You submit it directly to the land registry through us, and you manage it through our platform as well. So we've got a very nifty feature called the AP1 dashboard, which alerts you and the rest of the firm to any requisitions. And you can actually answer the requisition directly through InfoTrack and directly to the land registry operator as well. So yes, it meets that deadline, 2022, it's digitised as we speak.
Fabulous. The next question is for Ian, please. Do risk assessments have to be paper-based, or can the computerised ongoing risk assessments on a case management system be used?
Yeah, you can use a computer-based risk assessment, but having said that, it's a good idea for the fee earner to undertake a review of the file too, so that there's some evidence on the file itself that there's been some sort of personal involvement. But you can have a computer-based risk assessment, yeah.
Brilliant. This question is for Lisa. Is there a charge made to firms for the LMS link with InfoTrack?
No, there isn't. For your priority searches and your AP1s, there is no charge whatsoever.
Fantastic. This one is for both of you, really. Does either Ian or InfoTrack have a conveyancing risk assessment plan which is compliant with the guidelines?
I don't, Lisa. We don't as such, but we do have obviously security documentation, GDPR and so on and so forth that help you provide that detail as part of using us as a supplier in those terms, but not directly linked to CQS.
Okay, lovely, thank you. Please, can you confirm if it's acceptable for us to rely on the updates which we've signed up for with InfoTrack, where they notify us whenever a lender updates their handbook requirements, or do we need to do a search per matter? If the former, is it sufficient to record centrally that we're signed up for notifications with InfoTrack as evidence of compliance with the CQS requirement? Yeah, I think that came from Adele, and I referred to it when we mentioned about the lender handbook option that we have for alerts. When you get the alert, Adele, it will give you the documentation that you will need to save and put with the file via email of when those changes are made. If you haven't set an alert for that particular lender, of course, you can go to the lender handbook section on our website and get a document of a document of those changes retrospectively as well. So if you haven't got the alert set up, but you do realise there is a change, you can always go back and then search for that change via the lender handbook later. Okay, lovely. I think we've got time for just a couple more questions. The first one is, what should we be advising clients regarding lease extensions done by agreement? So where the ground rent reduction is only applicable on the extended term? Yeah, I can answer that one. The situation is that we're still waiting to hear from the government as to what the position is. Certainly, if there is an order made by a court with regard to a lease extension, then the rental would be a peppercorn. As to what the parties agree, then they can agree whatever
they wish. The point is that the law relating to the changes relating to ground rent only apply to new leases, not an extension of an old one. So what I'll do, Faye, is I'll keep you informed about whether I get anything further from the government. But at the moment, the attitude is that on a lease extension by agreement, you can still agree that there is a traditional ground rent, a monetary ground rent.
Fabulous, thank you. Okay, and I think we've got time for one last question, which is going to be one, and then we'll probably have to come back to the others independently after the webinar. So the last one is, how do we sign up for updates to the lender handbook?
Do you want me to quickly show you? I can do that, just bear with me. So if you are using InfoTrack, let me just show you how this is done. If we can get to InfoTrack, there we go. So within InfoTrack, in the bank check section of the workflow, you have lender handbook. Just simply give that a click. And as I mentioned earlier, you've got the right to search and filter on any part of the lender handbook as you go. You will see some tabs at the top of the screen, which is search for updates. So as I mentioned, if you haven't been alerted, if you've not set yourself up for alerts and you just need to get that document as evidence, you can do that via here. But manage my alerts is where you need to be. So as part of your log on with InfoTrack, this will go directly to your email address, and you just basically select which lender you want to receive alerts from. Obviously, I wouldn't recommend going for select all, because you will be probably inundated with emails from there, but you can actually just basically pick and choose which lenders you want alerts from. And this can be updated anytime as well. So if you need to add on, take out, you can do that. Select update my alert preferences, and that's all you need to do. It's done.
That's lovely. Thank you very much indeed, Lisa and Ian. So I think we are really overrunning quite considerably now, so I'm going to wrap this up. So I'd like to say a big thank you to Ian Quayle from Legal Training for joining us today, and also to Lisa Edwards from InfoTrack. And I hope that everyone has found this session helpful and informative. If you do have any other questions about anything you've learned today, or questions in relation to the changes to the core practice management standards for the CQS, then please contact us. Either reach out to your account manager, or you can contact Ian or Lisa, and their details will be shared with you with the recording after this, and they'll be happy to assist you. So as mentioned, this recording is being recorded, this session, and we will send you a copy so that you can refer back to it. So all that's left to say is thank you ever so much indeed for joining us this morning, and I hope everyone has a lovely rest of their day. Thank you very much indeed.
Thanks, everyone.
Thank you. Bye-bye. Thanks, Faye. Thanks, everyone. Thanks, Lisa.